It's 2:45 and all my coworkers are here to heckle me, so I guess it's time to get started. Hi, I'm Ben Jackson. I've been working with the Commonwealth for about 10 years. I started off as a person that was supposed to work one summer to install 27 computers, and here I am 10 years later. I'm a Senior Information Security Advisor for the Information Technology Division. We'll talk more about them later. First off, I'm going to make two apologies. First off, if my phone rings and it's my wife, we're expecting our first child in about a couple of weeks, so if the only reason she'll call me if something big happens, like he's arriving. So if that happens, bye. That's my recurring nightmare, which is why my phone is actually on and I didn't mute it. Second off, if you notice on my outline, 201 CMR 17.00, which I'm sure you're all itching to hear about, I had a nice, 20-slide, chapter on 201 CMR, and I ran it by legal, and the powers by be said, yeah, we really wouldn't want you to talk about that because everything should be going through the Office of Consumer Affairs. So, unfortunately, this is going to be a bit of an abbreviated presentation. We are going to cover everything else, though. Data breach laws, Chapter 93H, Executive Order 504. And thank God nobody's leaving. We're going to start off with a brief history of data breach laws. I think we all know the granddaddy of them all was California's Senate Bill 1386. It was passed in 2002 and went into effect July 1st, 2003. The text from basically the bill and now the law says, this bill would require a state agency or a person or a business that conducts business within California that owns or licenses computerized data that includes personal information as defined to disclose specified ways any breach of security of the data as defined to any resident of California whose unencrypted personal information was or is reasonably believed to have been acquired by an authorized person. I love lawyers. This, after it went into effect, was a proverbial light in the dark corner. We really didn't know how often laptops were stolen, backup tapes were lost, servers were compromised. Ethel in accounting posted 500,000 security numbers to her AOL homepage so she could work from home. This was basically, like I said, the light in the dark corner. Everyone suddenly started reporting to people in California, oh hey, we lost your data, sorry. And which was interesting because all of a sudden we'd find out that, somebody lost a tape in middle of New York City that contained, social security numbers. California got notified. However, no one else did. And we're all kind of scratching our heads saying, I'm sure my data was on there. I have an account with your guys. What's going to happen? Following this, Massachusetts, along with, I think, currently 43 other states between now and 2007, passed an act relative to security freezes and notification of data breaches. It went into effect October 31st, 2007, and that's called Chapter 93H. It's available on the mass.gov website if you're really interested into it, but we'll cover it briefly. Chapter 93H requires any group, public or private, suffering a data breach containing personal information of a Massachusetts resident to notify the Office of Consumer Affairs and said resident. Office of Consumer Affairs is a state agency. I'm sure if you do business, you do know about it. They handle all kinds of interacting with consumers, complaints about your business or other businesses, and working and does business regulations. The other two parts are it allows customers to freeze their credit reports if they're a victim of such a breach, and to make information safeguarding the personal information, which is 201 CMR 17.00. We are always talking about personal information. What is personal information as defined by Mass General Law 93H? It's a resident's Massachusetts first initial, or their last name, and either their social security number, their driver's license, or Mass ID card, which is, does anyone not know what a Mass ID card is? Okay, a Mass ID card, essentially, it's a license that allows you to say, it's a personal form of identification. It looks a lot like a license, but doesn't allow you to drive a car. Also, their financial account number, credit card, or debit number with or without any security code, access code, personal identification number, or password that would permit access to that resident's financial account. This doesn't apply to publicly available information from federal to state. Massachusetts has a lot of records that are publicly available. These records would not apply under this case. We're actually allowing them in other state laws to be public information. When does 93H come into play? When a personal information maintains, stores, or owns licenses data that includes information about the resident of the Commonwealth, knows or has reason to know about a breach of security, or knows or has reason to know that the personal information of such a resident is used by an unauthorized person or used by not for an unauthorized purpose. These are all texts from the law. This is why they all sound like legalese, because they are. I always love any presentation that lets me work in Carl Sagan. Has reason to know. Basically what that is it's covering their tracks of, do you, under regular circumstances, kind of know that something happened and data would likely has been authorized by access. And the quote that I worked in is, absence of evidence is not evidence of absence. As in, we've been breached, we kind of suspect that data's out there, but we have no proof that someone accessed our database. We just know that, okay, our database server got hacked. We don't know if they accessed our information. That's basically what that has reason to know is covering. It basically means, do you suspect, are you willing to, testify in the court of law or whatever that your information hasn't been breached? And chances are, if they've gotten to your database server or if somehow have accessed your information, you have to basically assume the worst case scenario that your data is out somewhere in the middle of the Eastern Europe. Like I said, if you even think your data isn't open, 93H is now in effect and you need to start notifying people. And I'm sure some intrepid person pretty soon is going to come up with the MGH 93H emergency button. Hasn't been released yet, but I'm sure that Ron Popeil or somebody is going to come out with this. So you've had a breach, and this is how it always happens. You've done all your firewall defenses, you got your IDS, your network's all secure, and all of a sudden someone accidentally uploads all of the data they want to have access from home and leave their laptop in the front seat of their car, which is then stolen. Whoops. So there's two basic classifications within 93H. It's someone that maintains, stores, or but does not or own licensed data that includes PII. Say you're owning an ISP and one of your customers' servers have gotten hacked. You need to contact the owner of licenser of that data. Another case in this case would be I know a lot. I came from a public health background. One of my previous jobs in the state. We don't own or we license data from somebody person, but we don't aren't controlling of it. Someone else's data set. We have to then notify them that, hey, oops. Someone that owns or licensed data that includes PII needs to notify the Mass Attorney General, the Mass Office of Consumer Affairs. They must provide notice to the agency of the relevant consumer reporting agency or state agency. That's basically a bit of legalese. A relevant consumer reporting agency. I think the best example of this would be, the credit reporting firms. If a Massachusetts government agency that is part of the executive branch, say, ITD, like my group, we also need to contact the supervisor of public record, and we need to start something called a cybercrime incident, which is a process at the Information Technology Division. What do you need to tell the Office of Consumer Affairs and the Attorney General's office? Basically, a detailed description of what happened and how it was unauthorized, how the access was unauthorized, and how did it actually go down. The number of the residents that were actually affected by it, steps taken to remediate the incident, any steps taken before we actually notified, before the notification goes out, after the notification goes out, and information whether law enforcement is engaged or investigating the incident. And this is basically to allow, if the FBI is doing or Secret Service or Mass State Police is doing an investigation into the incident, this will allow them to, we can actually work with them and hopefully delay any notification, so if it doesn't blow any type of investigation that's currently going on. How do you notify residents? Question in the back. Oh. Mm-hmm.
So the organization protects their laptops with strong encryption. Do we make the assumption that even the laptop is stolen?
If the laptop is, I believe 93H says, if the laptop is stolen and it's encrypted with a suitable form of encryption, and the key or the password isn't, say, written on the laptop or included with the laptop in some way, 93H does not come into effect. If you want, I can go make sure that that's the correct answer for you. Yeah. Well, him first. I'm sorry, I didn't.
If you have data for customers from other states,
Mhm.
are all the state laws consistent with that with the encryption exception, or are you possibly still kind of?
That I don't know. I'm sure that there's a hodgepodge of laws from other states. What the question was, this is how the encryption, I guess, whole kind of, or get out of jail free card works with 93H. Does that happen in other state laws? That I don't know. That's basically, it's going to be an interesting research project because I believe there's 44 states that have such of these laws, and I'm sure that some of them do not have such ways out. We had a question over here.
We just rolled out laptop encryption across the board. I believe 93H specifies 128-bit encryption. It does not specify what algorithm should be used, but that the key needs to be at least 128 bits.
Yeah, that sounds right. The key, according to this, the 93H doesn't actually specify the algorithm, but it specifies that the key needs to be 128 bits long. How do I notify residents? There's a written notification, an electronic notification, if provided consistent with e-sign, which is a federal law passed in 2000. It's in Section 15 of the United States Code, 2001C. I don't know anyone who actually has this type of pre-existing relationship with their customer base, so chances are it's probably not going to happen. Of course, you may have this already. There's also a third option called substitute notice. Substitute notice Chapter 93H allows you to do a substitute notice if all of these are demonstrated, or if any of these are demonstrated. The cost of providing a written notice exceeds $250K. The affected class of Massachusetts residents need to be notified exceeds over 500,000 residents, or you do not have sufficient contact information to provide the notice. Substitute notice consists of electronic mail notice, if you have the electronic mails of the affected customers, clear and conspicuous posting of the notice on your homepage. Can't just tuck it into the back there and hopefully it'll blow over. Publication in or broadcast through the media or medium that provides notice throughout the Commonwealth. Chances are, if you've reached this level, I'm assuming that you probably will get this broadcast through all the news agencies because you'll be on the 6 o'clock news. Who has this happened to? The Office of Consumer Affairs actually releases aggregate data. I believe it's every 6 months on notifications. It's available on the OCA webpage at mass.gov. I have a link for that later in the slides. 201 CMR 17.0, and I enjoyed this because it's our disaster recovery plan goes something like this, help, and I think that's unfortunately a lot of small businesses and other businesses have the same for an incident response plan. 201 CMR 17, it's the standards for protection of the personal information of the residents of the Commonwealth. It was created as a result of 93H. There's a little section in there that says, the Office of Consumer Affairs and Business Regulation shall adopt regulations relative to any person who owns or licenses personal information about a resident of the Commonwealth. This doesn't just apply to people doing business in the Commonwealth, people who are based in the Commonwealth. It applies to anyone doing business in the Commonwealth if you have information about Massachusetts residents. As for the specifics, like I said, I really can't go over that, unfortunately. I'm sorry. OCABR has been very helpful in answering questions. Through mass.gov, there is information regarding that. I have a link for that later on the slide. They have been participating in public outreach sessions with various industry groups. OCABR has been working with certain industry groups regarding questions regarding compliance. And they actually wrote a very nice small business guide for formulating a comprehensive written information security plan for people who need to have something start. It's not a comprehensive guide. It's just something to start people out, and I believe the line they use is that it's not going to mean, if you do this, it's not going to mean you're compliant, but it'll show you where to go. The link to that is actually hidden on their website, so I made a quick link. It's called is.gd JJJ capital G. Executive Order 504. Executive Order 504 is basically the government's answer to 201 CMR 17.00. It's basically showing that the Commonwealth is eating its own dog food. We are making sure that we're holding up to the same standards as the business Commonwealth as we are. Before Executive Order 504, there was Executive Order 412. It's to protect the privacy of personal information. That was it was put into effect June 23rd, 1999 by Governor Swift, remember her. Agencies for the executive branch of the government can only collect the minimum amount of personal information needed to perform their functions, and agencies need to review their policies and practices related to information about individuals. This was actually big news at the time. I believe I was working for the Department of Public Health, and we actually did have to go over and find out, because we dealt with a lot of statistics regarding citizens of the Commonwealth, and we had to figure out, are we collecting too much information? Of course, everyone says, no, we need all of this. And when you actually start going through it, you find out, well, no, we don't really actually need this. We don't need the other thing. So it was a pretty big deal at the time. Before Executive Order 504 also, there was two main security groups within the Commonwealth. There was the Commonwealth Information Technology Division, where essentially, this is my division that I work for. We're the Commonwealth Internet Service Provider and Managed Service Provider. We essentially provide internet connection to any state agency. And we also, if you want to have your, host an application, have a web application, have a massive SQL Server farm that you don't want to manage, we'll do that for you. We'll provide managed service for you. The other part of this was the Commonwealth's Enterprise Security Board. Essentially, it was set up in 2001. It was created by ITD, but kind of lacked official standing. It's a cross-section of Commonwealth agencies and authorities, local governments. Basically, they advise to security practices, and basically it's a giant powwow. I believe it meets every month to just discuss where we are, policies, and make recommendations on how the Commonwealth can become more secure. The ITD and the ASB work together to create policy on cybercrime and security incidents, electronic messaging, data classification, remote access, and wireless policies, among many other things. Unfortunately, before Executive Order 504, even with all these agencies and policies, it was a bit like herding cats. And again, I'm not sure if everyone can read that, but I think I'd rather manage a large software product. It's the daydreams of cat herders. Unfortunately, you can also easily say that I'd rather be managing, the Commonwealth security, because we did have policies. We had a lot of people who worked together, but unfortunately, we kind of lacked official standing try to tell people, you need to do this. We had policies that basically suggested ways of people should be more secure, but sometimes, these are very rare exceptions, that people would say, oh, hey, forget this. I'm not going to follow these policies. And it was more of a working together, sometimes with good results, trying to make sure that they were secure and everything was okay. We always won. It was just more of how much hair do we lose in the meantime. Executive Order 504 is the order regarding security and confidentiality of personal information. All executive agencies must implement the maximum feasible measures reasonably needed to ensure the security, confidentiality, and integrity of the personal information of the citizens of the Commonwealth. This is basically the key phrase for ITD, is we can now say, we love your application, we'd love to host it for you, but you're not currently meeting Executive Order 504. It was a nice little catch-all phrase. It also formally establishes the Enterprise Security Board, which is something we're really happy about. And it also revokes and supersedes Executive Order 412. Most of the information in EO 412 was restated by Executive Order 504. So we can't suddenly go back and say, oh, we're collecting all this new information about you. What does Executive Order 504 do? Well, it doesn't change any pre-existing contractual obligations with the state. So if you somehow do information or business with the Commonwealth, you're currently not, until your contract comes up for renewal, you're okay. You don't have to make any changes. Any pre-existing security or privacy laws, I think it actually supersedes most of them. It doesn't apply to non-executive agencies. If you all remember back to civics class and know how everything is constitutionally separated within the federal government, it's also the same way in the state government. Legislature, trial courts, authorities are not under this jurisdiction. However, both Chinese 3H and EO 504 say, you guys need to do this, or do something similar that matches the rules set forth. With Executive Order 504, all executive agencies must appoint an information security officer. develop a written information security plan, otherwise known as an ISP, and also must produce a personal data security and electronic security plan, an ESP. Must self-audit ESPs and ISPs at least every year, and have all employees attend mandatory information security training. This includes staff, supervisors, managers, and contractors. They also must verify all vendors and contractors have acceptable security controls to prevent data breaches. So any contractors that we do business to, we need to make sure that they're up to snuff. They also must fully cooperate with ITD to fulfill ITD responsibilities. ITD actually has some additional responsibilities underneath the EO504. It must implement its own ISP and ESP. We're going to have it verified by an independent party, so we can't just say, oh yeah, we did our ISP and ESP, we're going to check it ourselves, we did great. Issue guidelines on developing and implementing ISPs and ESPs, because basically we're currently developing our ISP and ESP. We're going to make guidelines, and because we're going through all the pain of it, we're going to make guidelines for all the other executive agencies to follow and say, okay, well, here's how we did it, you guys want to model after that. What we are going to review all ESPs and all ESP audits, and it also has to review all other agencies' compliance with Executive Order 504. Well, this is great because it says, you need to do all this stuff, but how is it enforced? Well, we did have this is basically the teeth of the order. ITD, with the approval of our Secretariat, the Executive Office of Administration and Finance, will determine remedial action if your ISP, ESP, or something doesn't up to snuff and puts you in violation of EO 504. We can then impose terms upon your IT agency's funding. So basically, we control the purse strings. So in summary, I'm sorry, this was very, very quick. If you have data on Massachusetts residents, you're sure to make sure you're already on the hook for making sure that it is secure, because if you get breached, you're going to have to deal with 93H. 201 CMR 17 is coming, and you need to learn about it. Don't ignore it or hope it's going away. It's probably going to cost you. And Executive Order 504, the government is eating its own dog food. So here's some links. The state homepage is mass.gov. Unfortunately, the links within mass.gov are a bit unwieldy sometimes, so I made tiny URLs for anything. I promise nothing nasty behind this, but if you really want to go, make sure you insert preview.tinyurl.com. 93H is tinyurl.com/chapter93H. The Office of Consumer Affairs and Business Regulations homepage and ID theft page is tinyurl.com/MAOCABR and MAOCABR ID theft. And Executive Order 504 is available at tinyurl.com MAEO504. Questions? Yes?
With regard to 93H, there is, you refer to you a lot of times, and I wanted a little bit of clarification on it. What I've been telling my staff is that they, each individually, are legally responsible for reporting a data breach. It's not us in IT, it's the person who discovers the breach.
Yes.
I've been telling people that they could suffer legal consequences if they know something and they don't report it. Is that a fair thing to say?
Definitely something that they should need to report it. It's basically, if someone sees something bad happening, they need to report it. I think it's, as for personal liability, I'm not sure. If you can give me your email address, I can make sure that I can find out for you. But yes, someone will be liable if someone notices something and doesn't tell anybody. I'm not sure who that will be, but if something, say for example, somebody loses their laptop, somehow manages to sweep it under the rug and no one notices anything about it. If that thing gets posted on eBay, so all of a sudden, Company X is going to find out, A, they have a laptop that has personal information that was discovered by someone who bought it on eBay, and that's going to all come back and it's going to get back to them. At least that's how I look at it. Do you have someone back there?
Sure. My question kind of builds on that. What are there specific penalties in place for businesses that are found not to be in compliance with this? Because obviously it's not like something you can audit for.
There's civil penalties. As for how it will be enforced, it's a question currently being addressed by the Massachusetts Attorney General's office. I don't know the specifics on that. That's basically another division that's, I just make sure that everything is going to happen on I make sure my shop's in order. I don't know how exactly that's going to affect the laws-wise. I know there's, I believe 93H makes reference to civil penalties.
Just reporting notification.
I don't believe that's addressed in 93H. I believe that might be addressed in another state law, but I don't know. I believe there's some type of guidelines for state agencies. I don't know about private businesses.
There are penalties and some guidelines in 93I, but that's for security disposal, not how.
Yeah. If you do want to talk about 201 CMR 17 from a completely non-Commonwealth endorsed perspective, talk to the guy in the back with the big beard. He's done some very nice work on. Yes?
Does any of the laws or any of the language talk about what you do with respect to protecting the passwords and how people are getting access?
Detecting what?
Protecting passwords or how passwords are used? Do you
I believe that's covered in 201 CMR 17.00. The actual business regulations are all covered there. Yes.
So is any of this in effect already?
93H went into effect October 31st, 2007.
But the 201 CMR 17.0, are any of those standards?
I believe they all go into I believe they go into effect on 1/1/2010. Don't quote me on that.
So every business has to buy it.
Yeah. As for the specifics, talk to OCA. Any other questions? Oh, yep.
Sure. This one's more of a, I guess, a philosophical one, but is it the sense of the department, or can you maybe provide any sort of framework around how there's been any improvement thus far based on implementing these? Do you have any sense of whether people are actually complying with this stuff and improving their capacity?
That's above my pay grade. I can't comment on that. I can tell you people who can comment on that, and I can give you their contact information. But any other questions? Yes.
Ben, do you mind just putting back this tiny yellow for a few minutes?
Oh, sure, not a problem. I think this will be up on my homepage, which I have a link to either, and I also think that'll be up on the source homepage. If you might want to talk to someone on staff on that, but I believe they told me that all the presentations are going up. Any other questions? Yes. Office of Consumer Affairs and Business Regulations. They've been very helpful. I believe they've, just basically you can email them and they can probably start working with you and answering your questions that you may have. They've been very helpful for, I know a couple of people that knew me and they knew I was in IT security, and they asked me, start to ask questions, and I basically introduced them over there, and I think that, that's the last I've heard about it, so I assume it was pretty successful. There's links on their homepage regarding, like I said, there's a small business guide which will show you basics on the information security plan. As for specifics, they can probably tell you what they have for, basically if you ask them with a general question, I'm sure they can start pointing out, because I'm sure that you're not the first one that has asked it. Uh-oh, yes?
I was just going to throw out a resource for the National Information Security Group, basic local chapter. This is a continuous topic on mailing lists, and we've had a couple of presentations thinking about as things come out for what everybody else is doing. And always, they're trying very hard to do it. They're writing the regulations, but enforcement will obviously be in the Attorney General's office. So some of the excitement is that somebody's going to enforce this. That's the world we live in, right? That's the world we live in.
Oh, yes.
One person writes the rules and somebody else enforces them.
No comment.
NAISG.org is a good resource for local stuff.
Yes.
On enforcement of 93H and 201 CMR 17, couldn't find where the penalty was for failure to comply.
That's an AGO question.
That's not sorry, what?
That's an Attorney General's office question. And I think that kind of goes back to what Jack was saying. Yes?
Do people ever see some kind of a superseding federal law, especially when that goes into some of the proactive things like the 201?
Speaking as a security professional and not an employee of the Commonwealth of Massachusetts, I would love to see a federal law. That's completely different. I mean, state government, I think we're all seeing it we've passed, I think 44 states have information data breach laws. I think I would not be surprised seeing something possibly within this Congress, at least attempting to get it done. Whether it passed, that's a different question, but I don't have a crystal ball. If I had that, I'd be very rich by now. All right, anything else? Officially, if you want to contact me and if you have further questions that I wasn't able to answer, my email address is ben.jackson@state.ma.us. Or if you have business cards, I'll take them and I will make sure that I contact you somehow. Or I can put you in contact with people. Or if you want to give me a telephone call, you can call me at 617-626-4575. Unofficially, and this has nothing to do with the Commonwealth, my website is innismere.net and my Twitter name is innismere. Thank you very much. Look at that. You get to have the second half of all the presentations.